This
Congratulations.
conference will now be recorded.
I'd like to begin with
Apologies for me up front that I should have put the recording on before and should have announced it before, but I'm announcing it now, and we are now recorded. Thank you, Professor Edwards.
yes, yes. So I would like to begin with a quick congratulations to the Institute for the Fiduciary Standard for its first win in its first ever outing filing an amicus brief. The Institute filed a brief with Tamar Frankel, um, sort of a legendary professor in Massachusetts and around the world who studied and written about fiduciary issues, for decades. And that brief, made some strong arguments that that the context around uh, investment advice has changed, and that trust is important, and that your ability to trust your financial advisor is important to the functioning of an economy. And you see a lot of that thinking and language echoed in some ways in the opinion. So one of the things that the opinion does that is a bit different than what we've seen from other courts is that it spends some time recognizing how dramatically the brokerage industry has changed over the last 30 years. So in the 1930s, when securities regulation really kicked off in the United States, it was an effort led by the states, and then Congress got into the act, in 33, 34, and thereafter. At that time, brokerages operated very differently than they do now. The Massachusetts Supreme Court recognized that the business model for brokers and registered investment advisors had moved much closer together. Brokers were casting themselves as financial advisors, holding themselves out as trusted advisors. And after the 2008 financial crisis in Dodd-Frank, the SEC studied the issue, and its staff report found that people could not tell the difference, generally between brokers and investment advisors. And so, because of that, most people in America now believe that their financial advisor owes them a duty to act, in their best interest, or give them advice in their best interest. And so that led to pressure to improve the standards for investors. Congress authorized a lot more than what the SEC did with regulation, best interest. One of the strangest things about regulation best interest is that it does not clearly require investment advice from a brokerage to put an investor's interest first. It just means, as far as I can understand it, that the brokerage can't put its own interest ahead of the investors. That's the language inside regulation best interest. So Massachusetts looked at this and decided that it didn't go far enough to protect investors from this problem. And it put out a fiduciary rule that would hold all brokers and investment advisors to the same standard, and that they have to give advice that puts the investor's interest first and without regard to the financial interest of the broker. So essentially, it's an argument that you should be able to trust your financial advisor's advice. So Massachusetts, put this rule in place to address the problem. The SEC's regulation best interest really has not gone far enough, and the opinion recognizes that the best way to understand regulation best interest at this point is that it sets a relatively low regulatory floor for how investors can be treated, but states can go beyond that and set higher standards. Now, this is important because it means that states have the ability to ensure that their citizens are protected from fraud, exploitation, and abuse. If they're working with a financial advisor and they have, as most people do, a mistaken set of assumptions about how that financial advisor has to treat them, this ruling means that states can do more to actually protect that assumption. What's been a challenge for the states historically is rulemaking in this space is going to face a lot of opposition from well-funded industry lawyers, and it's expensive and challenging, and a lot of states don't have the resources to take on those kinds of fights. So Massachusetts took the fight on and won the fight in a fairly convincing decision. I would expect that we're going to see more to come after this. I'd expect more states to grow bolder after this, and they should, because this is fundamentally, I think, the right result. So with that, I'll stop talking and be happy to jump in on questions.
All right, the floor is open for your penetrating and incisive questions. Who wants to be first? Yes. Could you identify
Okay.
yourself, please?
Yeah, I'm Dan. This is Dan Shaw with Financial Planning. Yeah, I'm just obviously the decision today was really grounded in the Massachusetts Uniform Securities Act, the powers that that grants William Galvin and his office. I think it's safe to say also that Massachusetts is pretty, aggressive in trying to regulate the securities industry. How much do you think other states might be stymied by the their own state constitutions, what those constitutions allow in-state securities officials to do, as opposed to the broader powers that are allowed in Massachusetts? That question makes sense.
So I'll take a stab at it. And the challenge for me is, states have very different constitutions, and it's difficult to give you an opinion, on that. I would expect to the extent other states have similar regulatory language, with securities commissions able to make rules and do things. Um, I would expect that they'll consider their options and be informed by this decision. But the structure of state securities regulators is very different, all across the country. Some of them are in the Attorney General's office, some of them are on their own, some of them, I think Virginia's is technically a court. So it's just a very different, it's a widespread of resources and structures for state securities administrators.
Uh, Ben, it was only 2 or 3 years ago, I believe, that New Jersey looked at this, and I don't know sort of why they, um, I guess, paused, but they obviously are in the background of the powers that be, so to speak. But there's one recent example. So
Yeah.
of a state looking
New
at it.
Jersey looked at it. It stopped moving forward. I believe it was more focused on digital engagement practices,
Yeah,
and this decision may reinvigorate that.
yeah.
So you may see more. It may also provide more support for the SEC to recognize that it may need to do additional rulemaking to improve regulation best interest.
Okay, thank you. Who's next with a question?
Bingo.
Mark?
Hey, Mark.
Mark's got to find his voice.
You might be on mute or a different microphone. I don't know.
Did I see Sam have his question up, his hand up?
Yeah, I did.
Okay.
Uh,
Okay, Sam, you want to go ahead?
Yeah, Sam Bojarski with CityWire RIA here. Two-pronged question, I guess, to the New Jersey point. What other states might be quick to act on this? And also, what about Robinhood's ability to conduct business in Massachusetts?
Okay, so I'll jump in. Nevada has a fiduciary statute. It doesn't yet have final regulations. That process has been very slow. This might accelerate it, might not. What'll happen in the future is very difficult to predict. I would not expect states to move overnight. They're generally thoughtful with limited resources, and so it's just very challenging, to predict. When it comes to Robinhood operating in Massachusetts, I don't see this as creating any real barrier to Robinhood being able to operate in Massachusetts. It might have to change the way it behaves because of that, but I don't see it not being able to offer services in Massachusetts because of this. So this is one of the things I think that probably may be helpful is to highlight how Robinhood, the brokerage industry has a variety of different business models. Many of them will have financial advisors and people who are meeting with their clients, who give personalized recommendations. And the application of the Massachusetts rule, now that it's been upheld, is very clear in that context. And so here it's going to have a very big impact. Robinhood's business model is slightly different, and there's an outstanding factual issue that's still going to continue in this case around whether or not what Robinhood does constitutes a recommendation. So if I tell you that I like salmon at a particular restaurant, is that recommending salmon at that place? It's hard to really know where the line is on a recommendation. If Robinhood shows you a list of movers and shakers, or presents you with leading stocks of the day, is that a recommendation that you trade those stocks? Maybe, maybe not. But if Robinhood designs its app and its website and its communications, all in an effort to induce people to engage in more active trading, that might fairly be deemed, a recommendation that people adopt a particular kind of trading strategy. Robinhood will have an interest in that because it makes money from payment for order flow. So the question that's going to probably continue here, and the decision doesn't address, is exactly what constitutes a recommendation. That wasn't really before the Massachusetts Supreme Court. This was just looking at whether or not Massachusetts had the power to make this kind of rule. And so where we're at right now, it's going to have an impact on the industry. It's going to change how advice is given, or at least impose more meaningful liability for giving bad advice. But going forward, there's still going to be a lot more for Robinhood to work on in this litigation. So it's so I think I would expect it to continue its business operations.
Mark, do you have have you found your voice? Yes.
Still nothing.
I don't know if you want to call in on the phone. That may be another solution. Who else has a question? Anybody else have a question?
This is James Tierney on the phone. Ben, you mentioned a little bit about what this might mean for the SEC moving forward, and I will admit, because of kind of childcare obligations, I haven't yet had an opportunity to read the opinion. But it's the way you've characterized it is as being mostly about kind of administrative power and whether they could adopt this rule in the first place. What do you see about implications of this decision, particularly with regard to the gaps that are identified in the existing federal framework and how a state might be able to move in? Does that have any does that like shine any light on what might be done at the federal level? And I'll take my question off the air.
Okay. So really, my thought here is that it may increase stakeholder pressure on the SEC, because there's been a lot of confusion about whether or not regulation best interest does enough, how far it goes. It's been oversold in some quarters as doing more than I believe it does. And my view on the pressure here is that it's likely going to be from stakeholders and political actors to push the SEC to go back and improve the way regulation best interest is drafted or enforced. So this is not to say that I have specific recommendations on that right now beyond ensuring that it requires investors' interest to come first in a meaningful way. But the thought process is, to the extent that states are feeling the need to enact their own protections, it tells you that there's a recognition that regulation best interest just didn't do enough to solve the problem.
I would add to what Ben said in terms of regulation best interest, that I think among truly independent observers, and you can throw in investor advocates, I don't think there is much difference of opinion about what Reg BI has or has not done. It is only when you throw the industry in there and they have such a unusual set of glasses. I think it's easy, maybe unfair, to basically discard most everything they say about that. I think what the states are looking at is not just what the administrator from this, or the secretary in Massachusetts looked at to jump in when he did, but look at what happened last year in terms of Reg BI. And there are 3 data points that I think that stand out in terms of last year. And the first one is a staff opinion in the end of March that says that you don't really using the word fiduciary on Form CRS is extraneous. This is the staff opinion. And there was no movement that we could see that the commissioners, at least 3 commissioners, thought this was inappropriate. So I think, just as a symbol, and because people say, well, nobody reads the Form CRS, so what difference does it make anyway? Well, I would beg to differ, but it's not just that. It's also the SEC comes out with its first big case on Reg BI, and several independent observers said that case could have been brought under the suitability rules. So another yawn. And then when the SEC came out, I think it was August, September, with another memo regarding conflicts of interest, there was nothing really new out of there. So I think there is a pattern so far that says that the SEC has determined that what Reg BI means, and it's basically what the state administrators' research tells us it means, and that's pretty much almost nothing thus far. Now, that being said, of course, someone could wake up tomorrow morning and saying that we have to start enforcing this, and that we have to start providing better guidance, and that would always be nice. But think about the progressive nature of this SEC commission, and I think that's a long shot, to put it mildly. So I just want to add that part in terms of the SEC and that context there. Next question. Joe, don't you have a question? Mark has a question. Mark? Maybe you could call it on the phone. I don't know whether that makes a difference. But anyway, that's a suggestion. Sorry. Anybody else have a question for myself or Professor Edwards? Going once.
May I ask a question from Canada?
Absolutely. We welcome Canada.
Thank you. Joe Kaloran. I'm in Ontario, Canada. Worn a hat as an investor advocate for about 35 years. Was trained by Merrill Lynch on Wall Street in March of 1984. Stayed in the Roosevelt Hotel, 16th floor. And a wannabe president, Gary Hart, had a suite down at the end of the hall. And we all know about his dalliance on the mob's monkey business yacht in Florida. And monkey business kind of describes Wall Street and the securities industry. Up here in Canada, we have the problem of suitability, best practices, and all sorts of other names for it. A lot of lipstick, different shades of lipstick on the pig. And it's interesting for me. My father was a lawyer. My grandfather was a judge. And we got a lot of fiduciary lawyers representing the industry, trying to stall, delay, not allow fiduciary as a standard in the industry. And it's kind of oxymoronic. The common good, public good, they're not championing it. But then a lot of lawyers are hired mercenaries, as we know, and they don't necessarily do what's right. They do what the money wants.
Joe, do you have a question?
Question is, up here in Canada, the salespeople were licensed as market registrants were licensed as salespeople until um, September 27, 2009, and then a hocus pocus overnight, they were relicensed as dealing representatives to get away from caveat emptor, and they're called advisors with the OR spelling.
Yeah.
And
Yeah.
we have the ER spelling up here, which is actually the fiduciary license, is the ER spelling, and maybe 5% or less of market registrants have the ER spelling, the CFAs, the portfolio managers, etc., who aren't necessarily dealing with the public per se on their
Joe, I'm going to ask you last time, if you got a question, we'd love to get it. Okay. But if you don't have a question, then I'm going to move on to somebody else.
Okay, I can't articulate the question right this second, so
Okay.
I'll sign off.
Okay. Thank you, Joe. Mark, are you there?
Can I try one more time?
The third or the seventh time, whatever it is, Mark is the charm.
Okay,
There you go, man.
finally. Thank you for your patience. Sorry, everyone, for putting you through this. Uh, so you say that there will be pressure on the SEC from stakeholders to amend Reg BI, but is the SEC already making a move, maybe a backdoor move, to strengthen Reg BI with this artificial intelligence proposal, where there is a provision, a rule, or where it says, you have to, everyone has to act in the investor's best interest, even if it's through an online mechanism.
Ben, do you want to go first, or do you?
Yeah, so I'm aware of the proposal, and I'm heartened by the direction that the SEC is taking there, um, and if um, if anything, I think when states feel like they have to act to protect their citizens because the federal rules aren't doing enough, uh, I think it provides more support for the SEC to be more aggressive.
Well, Mark, it would be nice if that were the case. My first reading of that is that that the language is stronger in terms of addressing conflicts. That's absolutely true. But and in this case, it may come down to how does the SEC define the word neutralize? Because that's a word that is introduced into its um, uh, dealing with conflicts. And if it weren't the case that the SEC has a very great history in defining words to fit what they want them to mean, I might be more optimistic. But I think that's what the record shows. And and again, even with Reg BI, very few people have noticed that they have demoted the best interest in the context of the definition of Reg BI, in terms of either putting the investor's interest first or putting the investor's interest parallel with the firm's interest, which is what the wording that we have now actually means. And there was a demotion there, but it didn't seem that very many people sort of took note of that demotion of the meaning of best interest. But anyway, I think only time will tell in terms of how that rule comes out and how it's interpreted and how it's enforced. So that may be a little while from now.
Great, thank you.
Any other questions? No other questions. Okay. Well then, I want to thank everybody for joining us. And if you have any follow-up questions, feel free to reach out. I want to thank Professor Edwards for joining us, and wish everybody to have a very good weekend.
Thank you.
All righty.
Thank you. Thanks.
Thanks, Knut.
All right. Well, I'll see you soon.
I will see you soon. Let's have a quick call offline, Ben.
Sounds good.
Okay, thanks.